Hey everyone! Welcome back to my new video. Today, we're going to discuss a very important topic for every creator. Which works are eligible for copyright registration in India, 2025 guide. If you're a writer, musician, artist, photographer, or even a software developer, this video will help you understand exactly which types of creative works can be protected under copyright law in India. So let's dive right in. In today's digital era, creativity holds immense value, whether it's a song, a book, a photograph, or even software code. Every creative work you produce is a reflection of your talent, skill, and effort. But in a world where copying and duplication are just a click away, how do you ensure that your creative work remains protected? This is where copyright registration plays a vital role. In India, copyright is governed by the Copyright Act, 1957, which provides creators with legal rights over their original works. Copyright protects not the idea itself but its expression, meaning the way your ideas are presented in tangible form, like writing, music, art, or digital code. But one of the most common questions creators ask is, which works are actually eligible for copyright protection in India? Let's break it down in simple language. What is copyright? Copyright is a legal right granted to the creator of an original work, giving them exclusive control over its use, reproduction, and distribution. In other words, once your work is protected under copyright law, no one can legally copy, distribute, or sell it without your permission. Under Indian law, copyright protection arises automatically when an original work is created and expressed in a physical or digital form. However, registering your copyright provides stronger legal proof of ownership and is highly recommended if you plan to publish or commercialize your work. Eligibility for copyright protection in India. The Copyright Act, 1957, recognizes several types of creative works as eligible for copyright registration. Each category has specific characteristics and examples, which we'll explore below. 1. Literary works. Definition. Literary works include any original writing, whether published or unpublished, expressed in words, numbers, or symbols, regardless of the medium. Examples: books, novels, and poems, articles, essays, and blogs, software programs and computer codes, databases and compilations, research papers and scripts. Even software code and web content are protected as literary works in India. This means your original coding, writing, or digital content cannot be copied or reused without authorization. Key point: copyright does not protect ideas or concepts, only their expression. For instance, if you write a story about friendship, others can write similar themed stories, but they can't copy your exact content. 2. Dramatic works. Definition. Dramatic works include any composition intended for performance, such as plays or screenplays. Examples: stage plays and theater scripts, screenplays and dialogues, choreographic works or dance performances. These works are protected if they are written down or recorded in a tangible format. The idea or improvisation itself isn't protected unless it's documented. Why it matters. Registering a dramatic work ensures your creative direction, and dialogue can't be copied in another production or film. 3. Musical works. Definition. A musical work refers to the combination of melodies, harmonies, or rhythms arranged in a particular sequence, excluding lyrics or recordings. Examples: original instrumental compositions, musical notations and scores, background music created for movies or games. The lyrics of a song are treated as literary works, while the music recording itself is considered a sound recording. So a complete song usually involves 3 separate copyrights: one for lyrics, one for the composition, and one for the recording. 4. Artistic works. Definition. Artistic works cover visual creations expressed in any tangible medium, such as drawings, paintings, and designs. Examples: paintings, sketches, and murals, photographs and digital art, logos, product labels, and graphics, architectural blueprints and sculptures. Even if an artistic work is used commercially, e.g., as a logo or product label, it is still eligible for copyright protection. Important note: copyright in logos protects the artistic expression, while a trademark protects its use for branding. Many businesses choose to register both for maximum protection. 5. Cinematograph films. Definition: a cinematograph film includes any work that visually records moving images, whether silent or with sound, such as movies, TV series, or advertisements. Examples: feature films and documentaries, short films and web series, music videos and advertisements. The producer of a film usually owns the copyright unless stated otherwise in a contract. This protection includes the visual editing, cinematography, and direction involved in creating the film. Why it's important: cinematograph film registration helps prevent illegal reproduction or distribution, like pirated copies on the internet. 6. Sound recordings. Definition: a sound recording is any recording of sounds, whether of music, speech, or any other type of audio. Examples: recorded songs and albums, podcasts and audiobooks, voiceovers and commentary tracks. A sound recording is distinct from the underlying musical composition, meaning both the music and the recorded version have their own copyrights. Tip: artists, producers, and studios should register their sound recordings to protect their work from online duplication or unauthorized streaming. 7. Computer programs and software. In India, computer programs are treated as literary works, but are specially recognized because of their commercial importance. Examples: web and mobile applications, game software, source codes and object codes, operating systems. Software copyright prevents others from copying, modifying, or distributing your code without permission. You can also license your software for commercial use. 8. Compilations and databases. Definition: a compilation or database is eligible for copyright if it involves skill, judgment, and creativity in its selection or arrangement. Examples: business directories, digital libraries or curated data sets, educational databases, product catalogs. However, if your database only contains factual data without creative arrangement, it may not qualify for copyright. 9. Architectural works. Architectural works are also protected under the Copyright Act. Examples: building designs and models, layout plans and blueprints, interior or exterior architectural drawings. However, copyright applies only to the design and artistic expression, not to construction techniques or functional aspects. Works that are not eligible for copyright protection. While the Copyright Act covers a wide range of creative works, certain types of content are not eligible for protection. Ideas, concepts, or methods. Only the expression of an idea can be protected. Titles, names, or slogans. These can be protected under trademark law, not copyright. Government publications. Some are public domain and not eligible for copyright. News, facts, or data. Without creative input, factual information can't be copyrighted. Unfixed works. For example, a live performance not recorded in any form. In short, copyright only protects original expression, not raw information or unrecorded performances. Duration of copyright protection in India. The duration of copyright depends on the type of work. Literary, dramatic, musical, and artistic works. Lifetime of the author plus 60 years after death. Cinematograph films and sound recordings. 60 years from the year of publication. Government or international works. 60 years from the date of publication. After this period, the work enters the public domain, meaning anyone can use it freely. Why you should register your copyright. Even though copyright is automatic, registration gives you a significant advantage. Here's why. Strong legal proof of ownership. Helps in case of disputes or plagiarism. Deters infringement. Registration details are publicly available. Commercial benefits. Easier to license, sell, or monetize your work. Eligibility for international protection. Under the Berne Convention, your work is protected in other member countries too. How to register a copyright in India, quick overview. Visit https://copyright.gov.in, the official portal. Create an account and fill out Form 14. Upload documents, like proof of authorship and a copy of your work. Pay the fee, 500 Indian rupees to 5,000 Indian rupees depending on the type of work. Submit and track your application. After scrutiny and verification, the Registrar of Copyrights issues your certificate of registration. Conclusion. Copyright registration is one of the most effective ways to safeguard your creative work in India. Whether you're a writer, musician, artist, software developer, or filmmaker, your original creation deserves protection. By registering your copyright, you gain exclusive legal rights and the ability to take swift action against infringement. Remember, your creativity is your intellectual property, and protecting it ensures that your ideas, time, and talent remain truly yours. About VMK Professionals. VMK Professionals is a leading firm offering expert services in copyright registration, trademark filing, patent registration, company incorporation, and tax and business consultancy across India. Our experienced team helps you protect your intellectual property with complete documentation support, quick filing, and end-to-end guidance under the Copyright Act, 1957. Contact VMK Professionals today to register your creative work and secure your rights under Indian copyright law. And that's it for today's video. I hope you learned something new about which works are eligible for copyright registration in India. If you found this video helpful, don't forget to like, share, and subscribe to our channel for more easy-to-understand legal and creative tips. Thanks.